Okay, we can have the next slide. Sorry, you will excuse me. I have a bit of a flu, so I hope I'll be able to be audible enough, as that is part of the etiquette we'll be discussing this afternoon. So the objective of the practice directions is to ensure that court procedures, courtesies, and formalities are adhered to by parties during the virtual hearing sessions. And the legal basis for the same is the authority given to the Honorable the Chief Justice under the following provisions: Articles 159 sub-article 2 and 161(2) of A of the Constitution of Kenya 2020, Section 10 of the Judicature Act, and Section 81(3) that empowers the Honorable the Chief Justice through the Rules Committee to formulate rules of procedure and or practice. So it is against this background that the current proposed practice directions were formulated. So I'll just be running us through those rules, and we're now looking at Rule 4 thereof, and that rule relates to the application of those rules, the directions. So these practice directions apply to all legal proceedings that have been conducted before the High Court, the Employment and Labor Relations Court, the Environment and Land Court, and subordinate courts as defined under Article 169(1) of the Constitution of Kenya. So you'll note that these practice directions do not apply in the Court of Appeal, and neither do they apply in the Supreme Court. Next slide, please. So Rule 5 deals with the conduct of proceedings. And basically, and I think this is very important because I think my brother Justice Mabeya will be speaking to the same. And the most important thing to note is that the virtual court proceedings shall, as much as the circumstances permit, be conducted in like manner as physical court proceedings. That is important because then we are saying that the usual rules of open court in terms of procedures, courtesies, and formalities shall remain to apply, and the parties are expected to observe and adhere to the same. In the same manner, all virtual proceedings shall be hosted by a person duly authorized by the judiciary, who will be referred to as the host. And the role of the host shall include, but shall not be limited to, admission of participants and orderly conduct and recording of proceedings. At this point, having been part of the team that formulated this rule practice directions, I'll be inviting us to have a discussion on whether we are satisfied with this rule, that is the judiciary is the host and the powers given to the host in relation to the same. Next slide, please. Rule 7 and 8 relates to notification of the parties. So the judiciary has the responsibility to notify the parties and the councils, and of course members of the public, of the link to use to join the proceedings. And that link should enable them to log in, join the proceedings, and that link should be provided at least 1 day before the hearing date. The notification thereof shall be by way of public on the course lists of the on the websites of the judiciary, the Kenya Law Reports, the Law Society of Kenya, be sent by email to the parties, and or be posted on public boards in the relevant court premises. Once again, if you feel that there would be any other mode of notification or manner of notification, hearing from you. And the very course list that will be posted shall indicate, among other things, the court in which the matter will be heard, the respective links of the presiding officers, the contacts of the parties, and of great importance, an officer of the court whom you may call for assistance. I know all had challenges in logging in and not even getting the link in time, so that should be able to be of assistance. Next slide. Next slide, thank you. So rules 9 to 13 speaks to virtual attendance. So authorized strong internet connectivity and stable power supply. I will just run through these areas because I am aware that my brother, Justice Mabeya, will be taking us through this in details. And where a part desires to screen share a document during the proceedings, we thought that it would be important for them to seek the leave of the court to do so at the pre-trial conference. The informing factor for this rule is that you do not want to stall a hearing because the parties did not deal with this issue during the pre-trial. So it's important that at the time the pre-trial conference is being conducted, the parties agree not only on the documents that they want, but the sharing thereof, the screen sharing thereof. We thought it would be important for purposes of identity that participants must log in using their official names. I'm sure, again, we can have a discussion on that. What constitutes official names? And is there any other way you can be identified? And then participants must be ready for the session at least 5 minutes before the scheduled hearing time for their cases. So that is dealt with under Rule 9 to 13. Next slide, kindly. Thank you. Now, Rules 14 and 21, I think, are very important, especially for the purposes of our training this afternoon. And I will therefore not be taking us through them in detail, save to say the following, that this Rules 14 to 21 addresses the dress code and the virtual court etiquette, which my brother will be speaking on this afternoon. And so in a nutshell, these rules deal with the following issues. 1, the dress code. 2, 3, choice of appropriate environment. And adherence to the time allocated. We know that when we are in court, we agree on how much time do I require. So we'll be discussing to find how is it different when we are having virtual hearing. They also speak to avoiding disruption during the proceedings and of course managing how we conduct ourselves and what we are allowed to have or not have. What do I mean by that? I'll just take us to the very last rule, which says that you are not to take anything in court in terms of food, in terms of chewing, in terms of anything, save for water. So since this is of this up, I will leave it and speak practical aspect of it when he makes his presentation. So the next rule, rather rules, are rules 2026 and relates to the database. These rules require that all Law Society of Kenya branches will have an updated database of all law firms registered within their region, and that database shall include all their details and contacts. It's only yesterday when I was told by a colleague that I think virtual hearing has come with this advantage because you can always log in whether you are a lawyer or not and address the court. So we may be looking at why this database. Sometimes I joke and I ask the lawyers, I may be able to identify you by your voice, but please prove to me that you are the person you purport to be, especially when it's not on the screen. The other day I had one who logged in as 22/2019. So I was not too sure whether that was the identity of the lawyer or the case. with that as it were. There we are. So the ICT team and the Law Society of ICT department shall share the database referred to above with the judiciary for ease of communication. Now, what mode of communication or platforms are we looking at? So we looked at Microsoft Teams, Skype, Zoom, GoToMeeting, and any other platform that may be approved and or directed by the judiciary as the formal medium of conducting the virtual hearing. Oh, sorry. You are not able to hear me. Can you hear me now?
Yes, Judge.
Okay.
Yes, we can hear you.
Okay, I saw right up there was a participant who couldn't hear me. Thank you very much. Thank you very much. So we can go on. We are saying that the highest possible quality of audio and video connectivity available will be used. Next. And then witnesses. This is another area we thought we would address. And we are saying under Rule 27 and 28 that all virtual proceedings parties, in all virtual proceedings, the parties shall agree in advance whether a witness and or a neutral person, and of course, I'm sure you'll be discussing who is a neutral person, may be physically present in the same room during the testimony of another witness. So where the court is satisfied that part of the proceedings should be conducted physically, it may order that physical attendance of such persons as it may deem necessary. So the issue here is, you know, when a witness is giving evidence, who else should or should not be maybe in the same room with the witness? What about the parties we're bringing to assist a witness who is not able to give evidence without assistance? So we could probably have a discussion on that. Next slide, kindly. Documentation, that is Rule 29. We are saying that all documents to be relied upon, which include, but are not limited to witness statements, exhibits, audio recording, video presentation, shall be made available to parties in the digital form in accordance with the provisions of the relevant rules of procedure. Procedures and digital platforms for transmission and storage of documentation shall be done by the court, and parties shall create secure digital platforms that permit or restrict the ability to download and or print the document shared. Okay. Now that, of course, naturally leads us to Rule 30, because we are now looking at confidentiality and privacy. We are all aware, of course, it's not anything that we can be spoken to, the need for privacy and confidentiality of court processes, unless, of course, they are public proceedings. And once in a while, you may want to protect the rights of the parties if they so request for the confidentiality and or privacy and or secrecy thereof. So we are then saying that it shall be imperative to ensure that the technology used allows all authorized, and you realize the issue here is all authorized participants, to feel secure about the confidentiality of the information they disclose. Access shall be strictly limited to authorized participants. Full names and roles of all authorized participants shall be circulated to all parties in advance and strictly adhered to. And the use of headsets is recommended to increase both privacy and audibility of authorized participants. And then parties may request an affirmation. I can see there are quite a number of people saying, I can't hear, so I don't know that the problem is on my side or on the other side. But let me just take that. We could come back if we need to. So parties may request an affirmation of privacy from all authorized participants at the commencement of the proceedings. Okay? And I am saying thank you very much, LSK Nairobi Branch, for the opportunity to bring to your knowledge the content of the proposed practice directions for virtual court sessions. I'm hoping that we can have a discussion on the same and see how to enrich them. I bring you greetings from the chair of the Rules Committee, Justice Odunga, and all other members, of course, including the members of LSK who sits on the Rules Committee. Once again, it was a pleasure this afternoon speaking with you. Thank you.
Thank you very much, my lady, for that presentation. It was very clear. I think we will take questions or discussions on the topic at the end after Justice Mabeya. So all the participants, if there's anything you'd like to discuss or any questions, you can lodge them in the chat and we will try and address them. Now, Mr. Charles Mwalimu will introduce Justice Mabeya and we will proceed.
Thanks, Amir. Let me take this opportunity to introduce our next speaker, Judge Mabeya. Mabeya will take us through the virtual court etiquette. Karibu, Judge.
Thank you, Mwalimu. Thank you, everyone. Amir, are you able to share my work or you don't have it?
I haven't been sent your slides, just my lord.
Start from slide number 5, I believe.
I have not received them.
Oh, you have not received that?
No.
Okay, now then that one, let me get it. Sorry, it was supposed to have been sent. Let me see whether I can be able to show it. Oh my goodness. Oh my goodness. Oh, sorry. Sorry, I think my goodness. Amir, I think my people are not here, the one who would have shared. Are you hearing me?
Yes, I can hear you.
I'm sorry, I do apologize. If you may allow me to present without sharing.
Sure.
Okay, let me proceed. Thank you so much, the LSK, the Litigation Committee, for giving me the opportunity to share my views with the members this afternoon. You may ask why the LSK. The LSK, if we look at sections sections 4, 5, and 6 of the Law Society of Kenya Act, it sets out the mandate and functions as well as the objectives of the LSK. And central to it is the maintenance of professionalism and integrity. professionalism and integrity. And what we are going to talk about is how are we going to maintain this professionalism and integrity in the wake of virtue courts, that is the etiquette of virtue courts. The advocate's conduct, first duty is to the law as well as the due process. Being an officer of the court, at all times, an advocate is expected to show fidelity to the law and respect the rule of law and due process. And my colleague has taken us through the due process as has been developed in the rules. With the coming in of the pandemic, we have now shifted from the usual physical courtroom to virtual courts. And what is it expected of us now when we are having the virtual courts? Court etiquette is a fundamental requirement in the administration of justice and to preserve professionalism, efficiency, and fairness in legal practice. So with the evolving of virtual courts, we are expected to maintain the traditional court etiquette as we knew it before the 2020 pandemic. In this regard, I will talk about how we are to prepare preparation for court, for virtual court, as well as during session and after session. In preparation, one needs to have at least all the documents one will need in court, either to have it in hard copy or in hard or soft copy in advance, as well before the date of the court appearance. You must ensure that all the documents are in the court file before one appears in the virtual court. It is important to brief your witnesses on the procedures.
My lord, sorry to interrupt you. I think I've got the slides.
Yes.
If you stop sharing on your end, I will share on my end.
Okay, go to slide number 10 then.
Just give me 1 second.
Thank you so much, Amir.
No problem. Please proceed.
Thank you. Brief your witnesses on the procedures on online court session so that you ensure that they are mindful of the rules, so that as you appear in court, there will be no interruption whatsoever. Enable easy access of documents for the witnesses as well as yourself and for the other parties, so that when you come to the hearing, there will also not be interference. My colleague has mentioned about sharing of documents on the screen before the date of hearing. Where possible, it is good to run a virtual pre-trial briefing with your witness so that they are familiar with the platform before the hearing. Next slide. Ensure that you have confirmed at the time of when the session is starting. We know that each judicial officer starts in his own time. There are those courts which start at 8, others at 8:30, others at 9:30. You ensure to log in at least, you've been told, 5 minutes before the court starts, so that you can do a test on both the microphone as well as the camera. And the same way, you do not have to come to court late. Please, it is important to attend the virtual court on time. Please, when you enter if you are late and you have entered the virtual court, please do not interrupt the proceedings. You wait until the end of the course list before you can call out or you request for the calling out of your file. Next. The next issue is how is one to be dressed in a virtual court. We have the LSK Advocates Dress Code, although it may not be exhaustive, but it is to be supplemented by common sense. The dress must be modest, nature which lends itself to the dignity of the legal profession. Flamboyance and garishness is discouraged. Advocates, in the usual manner, we are supposed to maintain a neat appearance and avoid appearing unkempt or untidy. Male advocates must always be in their ties and jackets. Let's move to the next. Shorts, jeans, and other fancy clothing is discouraged. For avoidance of doubt, advocates shall not dress down on any day when appearing before any court or tribunal. I always keep on advising the advocates that, like the doctors will be dressed for the appearance in procedure rooms, so should advocates be. Advocates are not teachers, are not butchers, are not any other profession. It's a professional that we must maintain. Your client, wherever they are watching, even if it is through the virtual court, must be able to see the maintenance of that professionalism. Next. There is a caveat in the Court of Appeal as well as in the Supreme Court. Even during virtual sittings, the wigs are optional, but the collars, which must be plain white, must be worn. Gowns, which must be plain black, must be worn. This is also, you'll find it even in the East African Court of Justice rules on virtual court. Indeed, in that court, you cannot be heard. There is no hearing for an advocate who is outdressed or not dressed as per these directions. However, in the High Court, it is as you appear in the physical court. Let's go to slide number 17. Now, before you enter the virtual court, then ensure that you have a very stable internet connection so that we do not have to lose you. You are not lost from your colleagues as well as the court. Check the lighting to ensure that you are visible and you can see. Test your laptop, tablet, phone, mic, and camera to make sure that you can be seen properly. Next. Your surrounding must be perfect for the court environment. It should be a quiet environment with very minimal distractions and sounds. If you are working from home, be in your own separate room away from the rest of the family. And it is advisable to avoid conducting the sessions from your vehicle, a restaurant, or generally an outside area where there may be some interruptions. Interruptions sometimes are very irritating, not only to the court, but also the other participants during court session. Next. Make sure you, when during the court session, make sure your face is evenly lit from the front, especially if you are presenting without natural light. Test the virtual background before using it so you are happy with the effect. Point the camera to your face, position yourself in the middle of the screen and look straight ahead. In most cases, you'll find that because of poor positioning, the judicial officer will be asking, where are you? I can't see you. Others will only be seen the rest of the top part of the face and not the real face. As my colleague said, it was talking to, is it real? Although the voice is being seen, it's good for the advocate to be seen when you are addressing the court. Move on. Muting the microphone at all times as you enter the court, the virtual court. It's very, very important. There is nothing that is worse than background noise during the court session. It is important, therefore, that the microphone is always mute, only to unmute when one is to turn on and speak. Always check that you are muted and your video is turned off before entering the session. The use of name. use your real name, the firm name or the individual advocate's name who is appearing in court. The use of nicknames or initials is uncalled for, so that you can be identified. I need to know the advocate who is addressing the court. Be courteous to the court and other participants during the virtual court session. Do not interrupt when you are not speaking. You will only talk when it is your time. Don't talk over other participants. The physical and facial expressions be appropriate and uphold the dignity of the court setting. Ensure the language used upholds the dignity of a court setting. Therefore, profanity is discouraged. Remember, a virtual courtroom is still a courtroom. It is discouraged. Do not eat or drink while you are addressing the court, or even when you are waiting to be called out. And that is why it is encouraged that have your camera off until the time you are called upon to address the court. Avoid using your mobile phone, even if the microphone is muted. Turn off your camera unless you are addressing the court, because it may distract the judicial officer or the other your colleague who is addressing the court. Next. Yes. When you're addressing the court, address the court. Do not address the court unless your matter has been called out. It's only when the matter has been called out that you should unmute both your microphone as well as the camera, so that you can be able to address the court. Introduce yourself clearly and address the court in a proper manner. Clarity is very important, and we know that with the virtual court session, most of all the proceedings are actually recorded. So for future use, for authenticity, it is good to be audible. Be audible and mindful of the pace that you are speaking. And on that, the summary of what we have talked about is being punctual, formal dressing, testing your connection before the court sessions, being mindful of the environment, that is the location, the lighting and background, having the mute button always. That is the best friend, because you do not unmute yourself until and unless it is your time to speak or to be seen on the screen. Turn on the camera when addressing the court only. Courtesy is required, both the same way it is required in the physical court, and at all times wait for your turn to address the court and be prepared. After that, of course, after the post-court, virtual court, it is expected that you will advise your client, because most of the times they may not be in the virtual court session. Note down the relevant directions, including dates and timelines, and proceed to file the documents that need to be filed using the judiciary e-filing platform. When opposing counsel was not on call or had network issues, as we see it on a daily basis, be courteous enough to update them and begin to prepare for the next matter, which definitely will be in another court. So as much as possible, my word will be that virtual court proceedings are and should be treated in as much the same way as open court proceedings. It is for us we are now adapting these great strides that we have made. And if we continue what we are doing and we improve on what we have done, then the delivery of justice, the administration of justice will be achieved. Thank you so much this afternoon.
Thank you very much, Justice Mabeya, for that presentation. It was very insightful and touched on a lot of issues that we all deal with on a regular. If anyone has any questions, feel free to post them in the chat, I can see that someone has asked Lady Justice Grace Nzioka whether the practice directions will be made available and when that may be, so that people can peruse them deeply and submit any comments or queries on the same.
So do I respond now?
Yes, please.
Okay, maybe I just needed to let all of us know that those practice directions were formulated initially by a subcommittee of the Rules Committee and presented to the entire committee, the Rules Committee, which has representatives from the LSK, I think the Nairobi branch and the Mombasa branch. And before the subcommittee came up with the first draft, we received a draft from the LSK. I do not know that it was Nairobi branch or it had been, been drafted and or in consultation with the entire LSK fraternity, the whole country. But be that as it were, we had a draft that had been prepared by LSK, which we took into account. And so where are we now? We've had a discussion on the feedback from stakeholders who had sent us their comments. We are at the point, or rather the Rules Committee as it were, is at the stage where this particular practice directions are supposed to be taken to the stakeholders for validation, and of course thereafter for gazettement. As you can see, they're supposed to have actually been gazetted by the outgoing or the Chief Justice who retired, and that was not done. So I want to believe that it's not too late for us to give our comments, and in that case, I'll just be suggesting that you write to the Secretariat of the Rules Committee, and they will send you a copy of these rules. You can still give your feedback on the same, and they'll see whether those comments that you will have given us were discussed and all the new comments that can be incorporated. But as it were now, we're actually working on almost the final, the Rules Committee is working on almost the final draft for gazettement. But as I said, kindly feel free to request for a copy from the Secretariat of the Rules Committee. And if you need contact of the Secretariat, you can probably let me know, and we'll be able to give you their contact. Thank you very much.
Thank you, my lady. Just staying with you, there's a question on whether it's appropriate for a judge to remove a member from virtual court hearings or proceedings generally.
That's for me to deal with. I want to believe there must be a good reason for the same. If that particular person is probably disrupting court process by not muting, or is in a background where it becomes impossible, and the court has spoken to them severally and they are not. Removal does not mean denial. You can be temporarily removed for purposes of allowing the court process to go on, and you are waiting in the lobby, and when your matter comes, you'll be invited back and the matter will be heard. So it really depends on what is it. And I think that is what Justice Mabeya has spoken to. We will not go into the nitty-gritty of what we have been, we have experienced. But if you are, let's say, in a background that is extremely noisy, and you are not muting, and the court can't go on, so the court has to stop, and you've been advised and you are not, I don't know. But my own take would be that it would be important not to remove that person, to deny them access to justice, but just to allow the proceedings to go on and re-invite them at the time, and then hear them and probably allow them to exit.
Thank you. Justice Mabeya, there's a question here that you may want to address. What happens
Yes.
when an advocate is not let into the virtual court session and adverse orders are granted?
What happens if an advocate is not admitted into a virtual session and adverse orders are made?
Yes.
That will be ex parte proceedings. If the admission was not deliberate, the failure to admit was not deliberate, if it was because of the internet problems, the equipment had problems, then that would be an issue of ex parte proceedings, which can, in the usual manner, be set aside and the orders be varied. But if it was for other reasons, which of course it would be required to show how and why he was not able to attend, then that is when the proceedings can stand. It is the same way. It is the same way, Amir, that when you are coming from Westlands or from Upper Hill to come to Milimani, and then there is an accident and the traffic holds you, and you come to my court late. That is an explanation under Order 12 Rule 3.
Thank you. There's another question. Someone has said that advocates have been making applications for refusal, though I think that is recusal, of judges and magistrates via the virtual court sessions. How best can one handle such applications?
Judge Nzioka, go first.
Okay, thank you, my brother. I think this is an issue we just had a discussion on the other day. Last week we had a meeting, which I had the privilege to attend, representing the presiding judge of the criminal division. And I think it's an issue we spoke, we addressed rather, and it's a bit sensitive. You know, traditionally, some of us having gone through the system, I thought the best way would be, first of all, to have an audience with this judge or the judicial officer privately and say that I would like to see you. But of course, now we do not have that opportunity. So I think if you have to make an application, I don't think by the fact that we are not having open court sessions, then that is a reason why you would make that application and then canvass it virtually without bringing it to the knowledge of the court for directions on how well it should be done for the purposes of the integrity and of the proceedings and the parties involved. Because when it comes to virtual hearing, you cannot control who was logged in. So I still think that it would be important before you make an application for recusal and canvass it to probably write and say, I would like to make this application for recusal, if it's possible. Is the judge or does the judge or the court have any objection to us making it virtually? Or what other alternatives can we use? Then probably the court, since now we are almost going hybrid as and when the circumstances allow, the court may decide for the purpose of this particular application, let me open myself to an open court and limit the number of persons who are attending, and then we can now maintain and preserve the reputation, the integrity, and of course, just, courtesy to the parties who are involved. That would be my take on it. Thank you.
I also support the position taken by my colleague, Judge Nzioka. By going virtual, having virtual courts, it does not mean that the physical courts have already closed down. Personally, in the commercial division, you know that all the hearings are now physical. But a recusal application is a very sensitive application. And as my colleague says, it's important. You can do a letter to the deputy registrar intending to raise the issue. Ordinarily, for all those, all of us who are trained on professionalism and integrity and the courtesy that we show to the courts, those are matters that used to be raised in chambers. You tell the court, with your colleague, judge, I have this issue, 1, 2, 3, my client feels blah, 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 blah. As I want to make an application for recusal. What do you think? Do I or we can have the matter moved from the without any match that contains one, professionalism, number two, the courtesy as well as the respect between the bar and the bench, other than being confrontational. Thank you.
Thank you, my lord. Your Ladyship, there's a question here with relation to Rule 27 and 28 on the practice directions. Someone is asking if you could kindly expound on the meaning of neutral person as provided in those rules.
Sorry, Mr. Amir, I didn't get the question. I think you broke off. I didn't get it. Rule 20? If you make
Rule 27 and Rule 28 on the meaning of a neutral person.
Yeah, you remember in my presentation that I expected that question.
Yes.
Now, we had a discussion on this the time we were discussing this. And I think in the physical court, we know that you may want, basically from the general understanding of the word, it will be a person who is not a partaker or a participant in the proceedings, who is not a party. So you're actually bringing in a third party to aid and abet, I mean, not to abet, but to aid the party. So let's take, for example, this person is an interpreter. Where would you place an interpreter? Would that, for example, be a neutral person? So we're looking at a person who is coming in to assist the witness, but who is not a party to the proceedings. That is how I would put it. And now we are saying that in a physical court, you'll find like the interpreter is there with that person. Now, where are we placing this person? So, you know, those are some of the issues we may have to have further discussions on, and we'll be very happy to have your input on the same. Thank you.
Thank you very much. Justice Mabeya, perhaps you can take the next question on how can it be ensured that witnesses are not being coached on what to say during their examination or cross-examination. This is a concern for most people. You could just have a piece of paper behind indicating some tips. So how do we protect against that?
Thank you so much, Amir. That is a very good and a very pertinent question. If you allow me, I will share an experience I've had with the virtual court session, where during cross-examination, when a tough question touching on the case is asked, then you can see the either the witness fumbling, and then internet provider decides to take it away, and you don't see the witness, so you are cut off, and it comes after 1 or 2 minutes and gives you a super answer. That is it has happened, and the best way to deal with it is during pre-trial, when I conduct virtual hearing, is to agree the lawyers that the room where the witness will be giving evidence from, a representative of the other party is there, so that there will be no coaching, there will be proper flow of evidence. Either both of them, you can go to you can do it from the boardroom of one of the advocates, or a representative is sent to the offices of the other counsel. As you are reading a document, and if he's reading a document, that is no evidence at all. And while there will be the issues of the, it's a difficult thing that they are trying to cope up. It is important to agree at that point that I'll be sending a representative, my clerk or whoever, to your office. Do the same on this other side. Thank you.
Thank you very much. It appears that we don't have any further questions. And Mr. Mwalimu, perhaps you can give us some closing remarks.
Mr. Mir, there is one
Sorry, Mr.
question.
Mir.
There's one question I've
Councillor
seen.
Mir?
There is
Yes.
one question I've seen,
Yeah.
where somebody is asking how, excuse me, is this, will the registry be notifying parties on matters listed for notices to show cause? Definitely, these through the emails as well as the cause lists, the issues of notices to show cause will be communicated to the advocates as well as to the litigants through the addresses that are provided. Thank you so much, Mr. Amir.
Mr. Amir?
Yes, my lady.
Yeah, there is a question. How are criminal matters being handled, particularly for remandees? If you may, I could probably respond to that.
Yes, please.
Thank you very much. So speaking from where I sit, currently we are dealing with applications, mentions, and of course, appeals virtually. And we haven't had a problem because the three main custodial institutions in terms of remands and or prisons are able to log in, and we are able to actually do and conduct virtual hearings without a problem. The problem we are having, and I thought that would be addressed, is that currently the lawyers who are representing the accused persons in murder trials are not able to have physical contact with them to get instructions. And that has been a challenge in hearing the murder trials. Because if they leave the institution or the remand prison, then they'll have to be kept at the police station because they can't go back and mix with the others. And I think that is something we'll be discussing when we meet the stakeholders on our bar bench meeting to just see how best we can deal with it. So basically, the murder trials, which we want to apologize that we were not able to hear for the last one full year because of course, the COVID-19 pandemic and the safety measures, Ministry of Health safety measures. We are happy to report that, we're going to resume hearing those matters because one of the challenge we had is that the courtrooms were condemned completely. And we could only have had those matters in an open court, which meant that we hear them in open tense. And we've had the institution procuring for us attend purely for those cases. So we are hoping that we will be able to call them to come in. The major problem, of course, is that you cannot bring most of these remandees for those trials unless, of course, logistics have been put in place. But the murder trials will be taking open court hearings. So for the criminal matters, I don't think we can avoid the hybrid system where we'll have part of those matters had in open court and part of them had virtually. I hope that response helps. I have also seen another question again, if I may, with your permission.
Yes, of course. Is this the question on contempt of court?
No, that there's dire need to expand more on a neutral person under Rule 27, Rule 27 and 28. And I know it was hotly discussed. And maybe we can revisit the discussion as to who the neutral person is, but I'll be very happy to also have suggestions from the other side, because I think the really important point under that rule is the need, and that speaks to the discussion herein on interference with the witnesses. So if I go back to that, it says in all virtual proceedings, parties shall agree in advance whether, so you can see that neutral person is not a person the court is identifying. The parties will have discussed during the pre-trial conference who else will be participating in these proceedings. You may call that person a neutral person. You may call that person a third party. But the most important thing is that you are identifying, other than the parties, who else will be addressing, participating, authorized to participate, and where will that person be? So it's an issue of discussion during pre-trial. And I wouldn't necessarily be concerned with neutral. I'll be concerned with the modalities that are applicable when this person is allowed to participate, and the ability for the parties to guide and agree so that there's no disagreement. So if you agree during the pre-trial that this person will participate and this person will be within the court premises, this person will not be with the defense or with the state or the prosecution or the plaintiff and the defendant, I think that is what would be. And this is even more important where the proceedings are partly conducted, partly orally, and probably partly virtually. If that is not, and it is unlikely to be satisfactory or is not, then we don't mind having a further discussion on that because we're just opening up the discussion. I hope that helps a little bit more.
Thank you.
Yeah, I've seen that question on contempt. I don't know whether my brother wants to speak to it.
Yeah, Justice Mabeya, there's a question here on what would be the latitude and scope of contempt of court in virtual proceedings.
Thank you, Amir. I had commented that virtual court proceedings are the physical court proceedings which has been changed into virtual. The same latitude that is in the physical is the what will apply. All that will be contemptuous in a physical hearing will be contemptuous in a virtual proceeding, because the virtual court proceeding is a court proceeding per se. So any conduct that will amount to contempt of court in a physical proceeding, likewise will be contemptuous in a virtual court proceeding. That will be my take. The only thing will be because the contempt no will not be physically near the court. It is summons which will be issued for attendance in the physical court so that somebody will be dealt with. That is my view.
Thank you very much. There is a question here on how does the court ensure neutrality of evidence in case of a virtual hearing when all witnesses are on the session at the same time? In a physical hearing, they normally stay out.
May I?
Yes, please.
I think our important take this afternoon is that the only difference between virtual and open court is that one is that physical attendance of the parties, the other one is not there. So if we have witnesses, we need, and that's why the hoster is important, and the person who is administering or managing the proceedings is very important. You have to, first of all, exit those witnesses until they're ready to be brought in. So that if my witness is testifying, the other witnesses must be removed from the call. That way, I want to believe then you will ensure neutrality. So that the way you ask the witnesses to go out of the court in an open court, so shall it be with the virtual. I hope that helps.
Thank you, my lady. And there's another question for you. It says maybe the rules should have a requirement for the court to communicate directions in advance or rescheduling of virtual sessions.
You broken off?
Apologies. There's another question addressed to you. It says maybe the rules should have a requirement for the court to communicate directions in advance or rescheduling of virtual sessions. In some cases, litigants log in and wait several hours before the session starts.
Thank you very much. I would like to take the very last bit of it. In some cases, litigants log in and wait several hours before the court session starts. The one-off rules should have required for the court to communicate directions in communication directions in advance. I'm not too sure about that because I'm not too sure how probably you give directions in the absence of the parties. But let me just speak to the last bit of this because I think it's important. You see, we all know that these virtual hearings, involve resources, not just in terms of finance, but in terms of even, the time itself. So when we were formulating these rules, I did say they're applicable in the High Court and courts of equal status and the rest, but they're calling upon all the practitioners, which means both the bar and the bench and all the stakeholders. So that really is more of an issue of management of proceedings before the court. In my opinion, and I stand corrected, and it doesn't mean that I'm not taking this. This is very good feedback, which will go to the Rules Committee to consider. So that's my first thing. We're taking it as feedback. I'd actually ask the secretaries to join us. But I think the issue of time management, both from the bar and the bench, is important. One of the rules I spoke to was, can we, when we have agreed on time, how much time do you require for highlighting your submissions? 5 minutes. And so 5 minutes are gone, I've hardly started. 10 minutes have gone. You can imagine the natural, the legal, the moral, the financial, and the general physical and psychological effect of
My lady, we seem to have lost you. Yeah, I think she may have dropped off.
Yes, the call. I hope once the call comes up, then she can continue.
Okay. In the meantime, Justice Mabeya, perhaps you can deal with the next issue.
Yes,
it says
please.
once conditions are back to normal, are there plans to continue the virtual system for applications, mentions, pre-trials, and the like, therefore reserving open court for hearings and viva voce evidence? This will really help in docket management.
Thank you so much for that question. By now, we should be prepared that there will be never physical appearances for mentions, appeals, directions, and such, and even applications. The position which on the part of the judiciary which we are taken is that virtual court system is here to stay. It has, we have seen that it is more beneficial. It is time-wise, there is a lot of saving as we are concerned. Going forward, physical court appearances will only be left for those complicated court hearings where there will be viva voce evidence. Therefore, the answer to that question is yes, because it is seen to be that time management is highly efficient with with the virtual court proceedings as far as applications, mentions, and pre-trials are concerned.
Thank you very much. I'm not sure if Lady Justice Nzioka is back. I don't seem to see her on the call.
Judge, are you there?
Justice Mabeya, someone has asked whether you mind repeating your views on the application for recusal of judges.
Judge will be joining us shortly while I answer, so that she can continue with the answer that she had given. So this could Justice repeat on application for a recusal of judges? As I had said, applications for recusal of a judicial officer from hearing a matter is a very sensitive application, both for the profession as well as the administration of justice. Ordinarily, these are those applications that used to be heard in chambers. What one has to do is to, through the deputy registrar, to inform the judge and the other party that my client intends to apply for the recusal of the particular judicial officer. Then you'll be called for a physical hearing of that application. You inform the judge the reasons why the client is putting forth. If the judge for the magistrate feels it is okay, we'll say, okay, put a formal application so that it goes on record. But if he feels there is no need to go that route, then you can say, okay, you can go to the next judicial officer. As those applications, if we remember our professional ethics from the Kenya School of Law, they are not a walk in the park. For that reason, it is very important as we take them, because we are here to stay. As practitioners, clients come and go. The client you have today is not probably the same client you'll have tomorrow. That the judge you have today will be in the Supreme Court when you'll be doing your election petition. Thank you so much. The judge is here now. She can be able to take you up. Yeah.
Welcome back.
I know. You know, interestingly, I'm not too sure it's working. So it's good that we are going through this, we are learning. So, and that means actually that was a practical demonstration of what I was saying. This virtual court etiquette is not about the bar. It's about all the parties who are participating therein. So that, you know, when we come to issues like I'm being kept too long on the call, then it calls upon the officer who is in charge of the process, the driver of the train, to manage the occupants of that particular vehicle. So that if it may then call for what I would call a mini call over or running through the course list, and this may not be a matter of a rule, it may be a matter of sensitization, because you cannot formulate a rule that will be universally applicable in all the courtrooms. So if it's possible, maybe the manner in which we list matters on the course list could help. If a mention can be listed before a hearing, or if a hearing can be, and if, you know, you can't be able to give directions to the parties and timelines, and the parties who've been given timelines are able to live within those timelines, we may be able to. But I know for sure in the course of the discussion, we did recognize the fact that, and the way my brother said, for good reason, a party may not be on call. As and when you come back, we will hear you as a court, and we'll decide whether your reason has merit, and we'll be open. And of course, as it's been said, unusual circumstances call for unusual solutions, and I'm sure the court will consider that. Thank you very much.
Thank you. There's a follow-up question with respect to recusal applications. It says, Justice Onguto, may his soul rest in peace, counseled us to make recusal applications eyeball to eyeball and serve it when hot in open court. Is that the best method?
Sorry, if you could just repeat that again.
It says, Justice Onguto, may his soul rest in peace, counseled us to make recusal applications eyeball to eyeball and serve it when hot in open court. Is that the best method?
Eyeball and serve it. In my opinion, certainly not. Okay.
Not the very best thing to do.
It's certainly not the very best thing to do. Let me just unsolicited comment. You know, there's harm that you cannot undo once it's been done. And by virtue of where we sit as judicial officers, it's very hard for us to hold press conference and say what all the parties who are in that court or on the call have been treated to is not true. When you eventually write your ruling on a recusal application, it's between you and the party who sought for your recusal. But in the ordinary course of hearing that application, you have no control. And that's why we are saying the privacy should be the way to go. If anything is the case, we are learned friends because we are brothers and sisters. And all said and done, we really need to just take care of each other. Thank you.
Thank you. I'm a bit conscious of time, and I think there are no more questions. So perhaps, Mr. Mwalimu, you can just give us some closing remarks as we end.
Yes, thank you, Amir. Judge, before I let Judge Nzioka go, I had just a concern or a question because she sits in the Rules Committee. Is the judge there? Yes, I hope she'll hear me. It's a question that I'm putting forth. What happens if a party appears virtually before a commissioner for oath?
Yes.
Thank you very much, Council, for that question. First and foremost, I think we've had the Rules Committee reconstituted, so I just want to let you know that currently I'm not a member of the Rules Committee because we needed to bring in judges from courts of equal status. And so the High Court that had 2 judges, I and Justice Odunga, had only one slot. And of course, I allowed my brother to be in the Rules Committee, and we brought in other members. Having said that, I've been in the Rules Committee for some time. So your question is whether it is proper, sorry, if you don't mind.
Yes, whether it's proper for a party to appear virtually before a commissioner for oath. Assuming I have a client who is abroad, and now that we've introduced ourselves to virtual hearings and virtual courts, whether it's proper and legal for a client to appear before a commissioner virtually for purposes of sharing an affidavit.
Okay, 2 issues. How will that person sign? And if we are going to recognize a signature outside the legally recognized signature, my and personal views, this is not for the Rules Committee, would be, then there must be certification by the person who is taking the responsibility of commissioning to say, I hereby take personal responsibility that this is what it is supposed to be. Because then there would be no any other way. If we opened it up, then I can tell you, we'll have very many commissioners of oath and as many documents as the commissioners can. And you can imagine what that means. I say no more. Thank you.
Thank you, Judge. Members, let me take this opportunity to once again thank you for taking time to attend this training. It is our first training as the Litigation Practice Committee. In a special way, let me thank our judges, Justice Mabeya and Justice Nzioka, for taking time. We contacted them on a very short notice. We really appreciate that they've created time to join us and give us this wonderful presentation, make us wonderful presentations. This is a series. This is part of the series of trainings that we are organizing at the Litigation Practice Committee. Very soon we shall be coming back with another training on trial advocacy. So we invite all members to always keep checking out for our flyers. So thank you. And let me take this opportunity to also wish you a nice evening, and may God bless you and wish you well in your practice. Thanks. And before I let you go, I also have an apology from our chair, the branch chair, Mr. Eric Deuri, who is held up in another meeting at the Kenya Bankers Association. We were not able to have him join us on board. So thank you very much. Have a nice evening.
Kirudisha yangu nifanye kazi sasa. Hii chakula si mbaya. Si mbaya sana.
Your microphone.